My name is Howard Stross, and I'm with Stross Law Firm located in Oldsmar, Florida. For several decades, we have been helping people in the areas of real estate and also in estate planning and most importantly, settling their estates. We want you to be an informed consumer, one who will understand what we got to do and also understand what you can do to abbreviate the time it takes and also to reduce dramatically the cost associated with doing so. When an attorney wants to help someone settle an estate, probate their estate, they have to first find out everything about that estate. Everything includes certainly the type of asset. Was it real estate? Was it a tangible personal property like a car? Exactly what was it? And then of course, how was the property held? As an example, in some banks, they will allow beneficiary designations on the account. If the beneficiary who is named on the account survives the individual who owns the account, that money, whatever it is, whether it's a few dollars or a large amount of money, will pass by contract directly to that beneficiary. And again, you have to ask the question of all people when we're planning estates, what do you want to achieve? Where do you want this property to go? Can it be used as a beneficiary designations? When we have trusts, we sometimes have the trustee of that trust as the beneficiary of that checking account. That way the money goes to the trust and that money is distributed in accordance with the terms of the trust. So beneficiary designations can be very valuable, very helpful, and they're at virtually no cost. There's no cost to set that up at a bank other than the time it takes for you to go to the bank and deal with it either in person or over the phone. So beneficiary designations can be great in many instances. Everybody thinks of beneficiary designations in terms of life insurance, as an example, where a person passes away, they designate their spouse. If their spouse is not alive, then perhaps their child or children. So beneficiary designations are very helpful tools in estate planning, but you have to be careful with them, because if you name somebody and that person passes away before you do, then there's no place to send that money or that asset. It'll end up being the subject of a probate. If one of your objectives in your plan was to avoid probate, then it failed. And I have to tell people this, most estate plans don't work. And the reason they don't is because people don't maintain the plan. They don't change the plan when it needs to be changed, such as a member of the family, or maybe one of the people that you were going to designate has passed away, but that was never changed. I can't tell you how many times we have seen parents of people who are 75, 85 years old have passed away, and their beneficiary designations were their parents, who are, of course, have passed away also. What does that mean? That takes that money, and instead of giving it directly to the beneficiary, it's got to go through probate. Again, the definition of probate is when you own something in your own name and you pass away, and it doesn't go jointly to somebody else, it doesn't go to a beneficiary who's been designated, it has to go through probate, and then it's dispersed in accordance with the person's will. If they don't have a will, I have news for everybody. We all have a will, whether we like it or not. The Florida statute, the law that's made by the legislature in Florida, that has been designed so that if you don't have a will, it'll go in a certain way. Oftentimes, most of the time, people don't like that. And so that's why I always tell people at a very basic minimum, one should have a will. That would be the very basic element to any good estate plan. My name is Howard Stross, and I'm with Stross Law Firm located in Oldsmar, Florida. And if we can help you, if you have any question, all you have to do is telephone 813-852-6500, and we'll set up a phone discussion with you, or possibly in person, depending on the circumstances at the time. But again, That initial discussion is not going to be at any cost to you. If you decide you do not want to proceed with us, that's that. There's no out-of-pocket cost to you. It has been an investment of your time, but you'll understand a lot after that first meeting. And thank you very much for listening.